pleasure, honor, and privilege to, on behalf of the Right Honorable Speaker, Femi Bajabiamila, and the entire members of the 9th House of Representatives, to welcome you all to this public hearing organized by the House Committee on Information, National Orientation, Ethics, and Values, for the purpose of collating stakeholders' views on the bills before us today. As globally accepted, legislative arm of government perform 3 major functions, that is, representation, lawmaking, and oversight. For the purpose of this gathering, we are performing the lawmaking functions of the legislature as enriched on in the provisions of the Section 4 of 1999 Constitution. Similarly, provided that the lawmaking power of the Federation shall be vested with the National Assembly of the Federal Republic of Nigeria, which shall comprise of the Senate and the House of Representatives. Flowing from the above, there are different stages of legislative process in lawmaking. One of the most important of this is the public hearing, which involves collations of the views of members of the public for the purpose of including their views into a decision to be taken on a particular law in making, while understanding the fact that democracy is about the people and the law are made for the people. However, the program is structured to collectively analyze the provisions of the bill, namely, a bill for an act to amend the National Broadcasting Act, Cap 11, Law of the Federation of Nigeria, 2004, to strengthen the Commission and make it more effective to regulate broadcasting in Nigeria, to provide the payment of all money received by the Commission into the Federation account in accordance with the Section 162 of the Constitution of the Federal Republic of Nigeria, 1999, and encourage literal openness and favorable competitions in the industry and for related matter. Number 2, a bill for an act to repeal the advertising practitioner registration Cap A7 Law of the Federation of Nigeria 2004 and enact the advertising practitioner registration licensing, etc. Bill for an establishment of a council for advertising practitioner as the apex regulatory authority for the Nigerian advertising professional and practice, and ensure smooth operation of the council for related matter. Number 3, a bill for an act to repeal the National Film and Video Censors Board Act number 40, Law of the Federation of Nigeria, 2004, and enact the National Film and Video Censors Classification and Exhibition Regulatory Commission Bill for classification of film, videos, work, musical videos, and video games, and for related matter. Number 4, a bill for an act to amend the National Press Council 128 Law of the Federations of Nigeria 2004 to remove bottleneck affecting its performance and make the council in tune with the current reality and regulating the press and for related matter. Number 5, a bill for an act to establish the Nigerian Institute of Translators and Interpreter and related matter. This is for reasons bordering on the need to have a law that will address the yearning and aspiration of Nigerians in their respective perspective. Therefore, it is pertinent to urge participants in this hearing to let the analysis and presentation be guided by the spirit of journeying towards Nigeria unity, sincerity of purpose, and resolve to have a better Nigeria through collective effort has been canvassed by the 9th House of Representatives.
The House Committee on Information, Culture, Ethics, and Values, ably led by the Chairman, Honorable Olusegun Odebumi, has convened this public hearing to allow citizens and stakeholders to review and contribute to the draft bills currently under consideration in the House of Representatives. Permit me to skip the mention of the bills that have just been read out by the chairman of the committee so that we can proceed with other very serious issues. Public hearings, public policy dialogues, and other such activities are an important part of the legislative process as they allow the elected representatives of the people to collaborate with the public in a joint effort at making laws for the good governance of the country and the welfare of all our nation's people. Each of the bills under consideration seeks to significantly alter the statutory framework of media, advertising, and intellectual property regulation in Nigeria. If these bills become law, the proposals contained therein will influence the creation of media content. They will determine the content of advertising, guarantee free speech, and establish institutions that will impact our country for generations to come. I say this to remind all the stakeholders, lawmakers, and citizens in this room that you have a tremendous responsibility to make sure that all the legislations that emerge from this process are of the highest quality, are in the best interest of the Nigerian people, and do not impose liabilities on our people or create the conditions that will allow for infringements on the human rights of the Nigerian citizens. You have a lot of work to do, and I am confident that you will do it well to the best of your abilities. I thank the chairman and honorable members of the House Committee of Information, National Orientation and Ethics and Value for their work on these bills and for organizing this public hearing. I thank all the stakeholders who have taken the time to be here this morning. I welcome you all to this House of Representatives and I wish you very fruitful deliberation.
Ladies and gentlemen, today is a day that one can say is very unique. Unique in the sense that public hearing is one aspect of the duties of the parliament to see how some of these activities can gradually lead to rest. Honorable Speaker, my work here is very simple. It's to thank all of you that have come to witness, that have come to partake, that have come to add value to this all-important day. Let me first by thanking God for making it possible for a day like this. Secondly, let me thank the Honorable Speaker. Even though he is not here, he has sent the House leader to represent him. Mr. Speaker, thank you so much. My chairman, let me also thank you for making it possible for everybody here today to see how we'll finally lay to rest on what we have come here to do. Let me also thank the committee members of all this important committee to have come to add value to what we are doing here today. Our Honorable Minister and his entourage, thank you so much for coming. And all other guests that have come here to witness today, let me say
it's about spectrums belonging to companies that have been granted licenses at this such. I think it's under powers to grant license. Powers to grant licenses. I want to say power to grant licenses. So my submission there, Mr. Chairman, sir, is that spectrums do not belong to licensees. Spectrum belongs to the federal government, and they can use it either for broadcasting, use it for telecoms, or use it for any other thing. There are situations where we give the impression, Section 9A is where the impression will be given that those who today are enjoying the spectrum will enjoy it forever. No, sir. Spectrums, at any given time, the federal government might decide who to give the spectrum to. And we must be careful that we do not give permanently a spectrum to foreign companies who might decide to do whatever they want to do with it. It is our hope that when we eventually transit from analog to digital, that the spectrum that is left will now be sold by the federal government to fund developmental programs as they may wish. But a situation where the impression is given, sir, that a particular yes, I think it's 9A, sir. 9A, sir. It's a broadcast service license, which includes television, radio, and tour, with the authority. I think it's. I think it's still it's under the broad classification of 9A. Yes, sir, but I just want to, when I'm submitting my written report, sir, I would definitely get the. Yes, yes, that's what I'm saying. I say, sir, there's a provision in the amended law here that asks that those who are today enjoying spectrum will continue to enjoy the spectrum. And I say that is like saying, it's like taking away the power of the federal government to allocate spectrum for what it wants to be. Spectrums, that's why we call them licensees. When we give you a spectrum to operate from, sir, you hold it as long as you abide by the laws, surrounding the grant. Anytime that the government you violate it or the government needs that spectrum, it will withdraw it from you. As a matter of fact, you don't need to offend. Like you remember that some cable operators, we took away their licenses, relocated them elsewhere because the government priority. It might be security, it might be economic. But I will please further.
I think, Honorable Speaker,
yes, sir.
Honorable Minister.
It's A2, I think it's 9.
In as much we will not consider the oral submission as the key. Your submission, written submission, is very, very key. So please, just make the submission on.
I will, sir.
So let's be waiting for that.
Yes.
Then I want to suggest that because we are considering 3 bills today, anybody we are given the opportunity to speak, I think colleagues, we can be speaking on the 3 bills, or your submission on the 3 bills, so that we will not be going back, front and back on them. If it is accepted by the whole household, yes. Do we agree to that? No. It's okay.
In the code of the MBC, sir, that is where we spell out, things that have to do with competition. And then 19B, sir, the cross ownership. If you read it very well, sir, it smacks like witch hunting. When we say, if I own this television station, I own this radio station or this newspaper, I cannot own this. But what makes it a bit obnoxious, with due respect, is the fact that immediately after this law is passed, they are going to now have an inquiry into those who are already holding it. It will look as if it is witch hunt. But I intend to put all these things from a perspective in my write-ups. But those are the few, those are the few observations I've made. Except that also in section 6, section 2, so under the powers of the commission, it appears as if there's a bit of confusion. When you said the under 2A, powers of the commission, that the commission shall have the following responsibilities pursuant to this act: to formulate the formulation of policies, monitoring of the broadcast sector, issue directions of a general character, and matters of broadcast national policy consistent with the objective of national security and economic development. It's a bit misleading, because if it's don't read it, it's as if you have taken away the powers of the minister who can give general directives, but you did not touch it. You did not touch the power of you did not touch the power of the minister under section 6. But there's a bit of ambiguity on the kind of directives. The commission can give directives probably to the licensees, but only the minister has the power to give directives of a general nature to the commission, which must be obeyed by the commission.
That we have recognized are actually gaps having to do with the independence of the regulator in this act. All over the world, the international standard is that the broadcasting regulator should stand as an independent entity, recognized in law as such, able to perform all the functions of a regulator. And that is not happening in Nigeria, and this law has not made such provisions. I'll quickly go into the issues that go with independence, the recommendations. Recommendation 1, sir. Section 21B should provide for the commission the power to approve licenses without reference to other government organs, while section 21C should be removed. 21B is the one that says the NBC should just be a post office, just to collect applications and not do anything. 21C is the one that says the minister and the Mr. President, should do the approval. So we are saying that one should be removed. The regulatory body should have the power to issue licenses. Number 2, sir, in section 3, the board members should be properly designated as commissioners. Representatives of the State Security Service and the Ministry of Information should be excluded from membership of the board. Members of the board should be appointed by the president upon consultation with the groups that they represent and confirmation by the National Assembly. You must just have this oversight. Executive cannot be doing this alone.
Talk about the NBC Amendment Bill, HB 833, which seeks to regulate tariff and subscription policies of satellite digital television services. So for us details, we think that bill is not in conformity with the way the market operates in terms of the market forces. For us, we think prices of television services should not be regulated by, should not be subject of regulation for these following reasons. Digital television services are not universal services like the public broadcasting services or telecom services, which are public utilities, which need to have universal access for everybody. They are just discretionary services which people or consumers buy based on a contract they enter into with the service providers. So these contracts are what regulates those relationships. And those contracts should not be subject of regulation, because they should be, both parties should be given the free will or space to operate within those contracts.
And that is the point that, just to illustrate the dynamics of regulation, I think certain things should be left within the code so that we're not too fixated with laid down laws. Because if you look at how much time it's taking us to review this act itself, it shows that we need to stick to regulatory instruments within the code. And as part of that is also to state within this legislation the need for standardized rulemaking procedures that the Commission should take with regards to the code, so that there are certain rulemaking procedures. You declare, so that we state it one by one, leading to how the code or any other rulemaking is adopted by the Commission. I think it needs to be well stated, so that if the Commission is going outside of that, then we know, we as stakeholders in the industry know that the Commission is going outside of that. On the licensing of DSB, Digital Satellite Broadcasting Services, I also want to say that I agree with the proposal made in this act that certain bodies that were precluded before should be removed.
My concern here is with HB 833, which seeks to grant the National Broadcasting Commission powers to regulate competition in the broadcasting industry. These powers have already been granted to the Federal Competition and Consumer Protection Commission by virtue of the Federal Competition and Consumer Protection Act, which gives that commission the exclusive remit to deal in matters relating to competition. For instance, Section 104 of that law says that in all matters to deal with competition, the provisions of that law will override the provisions of any other law except the Constitution. So why do we want to make laws now that are already overridden by a law that has been passed by this same National Assembly? The second point I would like to talk about is about price regulation. Price regulation would be relevant in a regime where there's government subsidy, so that participants in that industry will be able to recover their expenses.
Processing process. And the point I just want to raise as the issue here is that unlike other regulatory institutions, such as the National Communications Commission, the appointment of the board, including the DG of the NBC, is not subject to the confirmation of the National Assembly. We think this should not be the case. For us in the media, we take note of the fact that the NBC in recent times has taken actions against broadcast media that we believe are politically motivated, including the imposition of hefty fines. And that is why we think that this amendment should help to promote the independence of the NBC. The specifics of our recommendations, which align with that of IMS, includes the fact that the Act should be amended in such a way that the constitution of the board, just like others, is done through a process that involves the confirmation of the National Assembly. Then Section 2, functions of the Commission. Section 2C of the amendment bill we propose that should now read, receive, that is functions of the commission, process and consider and approve applications for the establishment, ownership, and operation of radio and televisions.
Advertising as a sector provides not less than 80% of the income to the government-owned media houses, while to the privately owned media houses, advertising generates not less than 90%, in some cases 100%. I want to make a request to the Honorable Committee, sir, that they should consider a seat on the NBC Government Council for advertising that represents the income. The going concern of broadcast media houses depends on advertising. And we felt as a strategic partner in this whole conversation, advertising should be represented in the ecosystem. DGs of parastatals, gentlemen of the press.
Adopt all the protocols.
Please, our own is simple appeal. So may I, on behalf of the Voice of Nigeria management and staff, appeal that we were included in the digital access fee because we were omitted briefly, especially when our sister agencies, the Nigerian Television Authority and the Federal Radio Corporation, were handsomely captured and obliged 10%. We are appealing because we are supposed to be the BBC of Nigeria, the Voice of Nigeria, Voice of America of Nigeria, and we are trying to upgrade our services to compete favorably with our colleagues. And by law, we're not allowed to generate funds or place or collect advance. So it will not be fair if a child is not treated like the other children. So we humbly appeal that we are included.
Section 11, you see, we have left a blank space there. You can only refer to the existing provisions. But our proposition here reads, Section 11, Ratau suggests that students of advertising and other related disciplines should be added at the fourth part. Section 12 to Section 1, D, Ratau is of the view that age 21 should be changed to age 18, which gives people independence and legal recognition as contained in the Constitution of the Federal Republic of Nigeria.
The name change recommendation as made by the APCON registrar is something also that we wish to adopt at this time, considering how it continues to impact on the operations of the advertising industry in Nigeria. Part of what has perhaps impacted negatively on our sector is the fact that quacks, if I might call them that, can go to court and get away with not being regulated simply because the laws sound as if they are not part of the regulation. So I think this is very central to this very laudable thing that you're doing here.
The advertising industry has evolved, first from the word advertising. Today it's about marketing communications. So the HASG, which I represent as chairman, is made up of 6 sectoral groups. 1 is the AAAN, 2 is the X-Man, that's Experiential Marketing Agencies, 3 is the Media Independent Practitioners Association of Nigeria, 4 is the Out-of-Home Advertising Agencies of Nigeria, 5 is ADVAN, the Advertisers Association of Nigeria, and then finally BON, Broadcasting Association of Nigeria.
This public hearing, and I want to assure you that as stakeholders to the information, national orientation and ethics and values, we appreciate what you are doing because this is going to really enhance public participation in your role as people that are enacting laws that govern the way we do things. Secondly, with regards to the NBC code, I would like to concur almost 100% by what has been suggested by this gentleman. I've forgotten his name, but I think we need to look at really the independence of National Broadcasting Commission. It's very critical because it is an agency that is supposed to package who we are and how we are as a people.
My most senior distinguished creative colleagues, we are here together. Well, three of us are here. I'm sure the other person, Mr. Madu Sishikwelu, will soon be introduced you to step forward. I agree everything. I adopt what most senior Alhaji Abdul Karim just said. Our concern, because we are a critical stakeholder in the entire ecosystem of the MBC, our concern is how to, it's an appeal that as we are reviewing this law, how Nollywood, as an industry, a very viable industry, can be dragged into the net of beneficiary of some of these, the collection of some of these revenues. I believe my colleague too, Mr. Madu Sishikwelu, will speak more on this, because so that we won't repeat ourselves.
Stakeholders, colleagues, my name is Madu Sishikwelu, filmpreneur Madu Sishikwelu. I'm a specialist on audiovisual, public policy and culture. First, I had planned to speak as a group, so that's why my colleagues were taken by surprise, so we had made our decision together. We in Nollywood want to be recognized as genuine and major stakeholders in the broadcast sector. Thank you, sir. Most of this is because, for instance, this amendment is a bit of a surprise to us. We stumbled on it. All right, and I would have loved to speak as eloquently as my older brother here. Unfortunately, one does not even have these documents to look at. So I think that first and foremost, the National Assembly should make it a statute that before any institution or organization is making a review of the extant clause, they should provide evidence that the stakeholders have been notified. So who have a situation where people are going behind to do Jakara laws and take to National Assembly?
I'm going to make comment on one of the three bills before you for review. In the first instance, you have the right to make a comment on three bills. I'm restricting myself because of time to only one. In the NBC bill, under the objective of the Act, it says that it provide a clear allocation of roles and assignment of tasks between policy implementation. I think that should change to what you have there on the law is policy formulation. Policy formulation is in the ambit of the ministry and the office of the minister. The implementation is for the agency. So that clarification should be made. Under scope of the Act, page 2690, line 6, they were talking about recommending application through the minister for the grant of radio and television licenses. That is very limiting. The authority of the NBC to grant licenses covers all categories of broadcast licenses.
Otenigo, Otenile, Otelode, Otenigo. Yes, I will be brief. I will be very brief and not waste your time. I'm actually going to focus on APCON bill that is before this honorable House. As you are aware, when APCON Act came in as a decree in 1988, it migrated from a self-regulatory system and became a statutory regulatory system. Over time, it acquired a new system known as the hybrid system, which is known as co-regulatory system, where APCON, together with the sectoral bodies, with their codes, as well as sectoral organizations, work together to regulate advertising. But where we are now as a nation, we are at a point where the National Assembly needs to wade in. Intervention is required from the National Assembly. The two cases that went to the Court of Appeal, which the court shut down APCON, are Microya Limited versus APCON, and the second case was the APCON versus the Registered Trustees of International Covenant and Ministerial Council. Now, the Court of Appeal in these decisions attacked the applicability of APCON Act to non-registered advertising practitioners. Okay.
So I represent the Advertisers Association of Nigeria, and by advertisers we mean the organizations and the brands that advertise and that engage the services of creative agencies and media buying agencies. So essentially, advert funds this industry, the advertising industry. Our members control about 90% of advertising spend in Nigeria. There's a saying we normally bandy around in our meetings that he who pays the piper should dictate the tune. But we're not here to dictate the tune. We just want a seat at the table. Thank you. So my comments will be in line with what my colleague has said, because we're also part of the HASG, and I believe he has spoken and represented us well. But I just wanted to add one or two things in contribution to what he said. So the first being, I want to reiterate the need for the board of the Outcome Council to be truly reflective of the current advertising industry. When the initial law was enacted, the advertising industry, the look of the advertising industry was totally different from what we have now. We have totally evolved in the activities of advertising and marketing in Nigeria. So we welcome this amendment because it is well overdue.
The three areas that I've been asked to highlight are, first, Section 13(1), 13B of the proposed bill, which deals with the issue of renewal of licenses. We have observed that there are some provisions in that bill that talks about penalties for non-applying on time. There are some provisions that talks about revocation of licenses for non-renewal. And we believe and submit and plead that the committee should harmonize these various aspects. It's dead. So that's why we're saying that if there is a little bit of delay in application for renewal, the committee could look at it and impose fine instead of revocation. Yes, because there's a provision which says that if you don't apply on time, penalties could be imposed. If you also don't renew on time, instead of automatic revocation, there ought to be some penalty. That is what we're applying and praying that the committee should consider. The other aspect, Mr. Chairman, is the aspect of yes,
so we have your document.
Yes, legal proceedings. That's Section 19. But Mr. Chairman, the committee, the bill is saying that if you want to institute legal action against the NBC or any of the officials, you have to give 30 days notice before that action can be commenced. That's what we call pre-action notice in law. But, Mr. Chairman, if you look at broadcasting, if, for example, you you suspend my license, and I need to rush to court, I have to wait for 30 days. And before 30 days, I can't do anything. We know it's like the landlord wants to throw a tenant out of the house. And you want to wait for 30 days to give the landlord notice to go to court, whereas you can have injunctive relief. Because there are occasions where, in the past, we have asked for injunction to restrain some acts while substantive matters are going on.
Honorable members of this committee, the Honorable Minister present here, I'm here to strengthen the enactment of NITI bill into law. First of all, let me say that when Nigeria and other African countries have been in a problem on sustaining the
point of order. Chairman. Your name, who you represent?
I think that my name is Professor Hafiz Mikoya Kasai, the current national president of the Nigerian Institute of Translators and Interpreters. I teach at Bayero University, Kano, Department of Linguistics and Foreign Languages. Thank you, Mr. Chancellor. Okay, the issue of sustainable development. For over 50 decades, Nigeria has been trying to have a sustainable development for this country, but it couldn't get it. Why? Because there's something missing. And the issue of translation is one of the gaps, is one of the things that we haven't got it in the right direction, or proper attention has not given to translation. Mr. Chairman, sir, if you look at it here, the people, the developed countries that we can think about, when you look at it, you will see how they consider translation, the relevance they have given to the idea of translating from other languages into their indigenous languages. This, I think, is a big problem that hinders the sustainable development in this country. And indeed, if we would all recall, recently, the Honorable Minister of Education has been saying that there is need for teaching of mathematics and sciences in our indigenous languages, particularly that according to the National Language Policy from primary 1 to primary 3. This could not be achieved without this professional body, that is the Nigerian Institute of Translators and Interpreters.
The only thing we want to add, I'm Shola Akishiko. I represent the Outdoor Advertising Association of Nigeria. And the chairman of the HASG, Mr. Femi Adilusi, has encapsulated everything that we wanted to say. Just that one more point. And that is that our sector is over-regulated. We suffer from over-regulation as at today. 1, the individual has to be registered by APCON. 2, our businesses has to be registered by APCON. 3, the various local governments are coming up to regulate and control outdoor advertising. So many states have signage agencies that control outdoor advertising practice in Nigeria, and that leads to multiple taxation. It leads to multiple problems for us. And that's why you see so many of our billboards vacant out there, because at the end of the day, it translates to more money to be paid by the advertiser. And that was why our client was complaining. Let us streamline all of this. Let APCON has the power to control advertising practice, including outdoor advertising.
I want to appreciate every one of you that have come here to make one form of presentation or the other. We are believing that all the presentations, submissions, contributions, recommendations made will be well taken. We also want to believe that all of you will be proud of the final bill that will come out, and Nigerians and Nigeria will be happy. And so, we want to thank all of you for coming. We believe that anytime there is a need for us to gather, please try and come so that we put our heads together in this type of public hearing so that we can move this country forward.
To move for the adjournment of this meeting. Thank you, Mr. Chairman, for this privilege once more. My name is Honorable Arogundade, representing a ward of Federal Constituency, Lagos State, a member of this committee at the Lagosha. I want to move that, having considered all the bills we provided and listened to various questions and submissions, I want to move that this meeting should stand adjourned till tomorrow. Thank you very much.
I support the motion that we move this meeting on tomorrow, 17th of June, 2021. I suspend.
The leave of the house and the permission of the people we are present, I hereby move that we adjourn this meeting tomorrow, 11.